Welcome to the AskJunior Daily Judgment podcast. I'm Priya Matthews, and joining me today is my colleague Arjun Kapoor.
Hello, everyone. We're excited to dive into today's important judgment about Jet Airways' insolvency resolution. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right, your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Today, we're looking at a landmark judgment in State Bank of India, v. the Consortium of Mr. Murari Jalan and Mr. Florian Fritsch, which deals with the implementation of Jet Airways' resolution plan.
This is a fascinating case that really showcases the challenges in implementing resolution plans under the Insolvency and Bankruptcy Code. Priya, why don't you start by giving us some background on what happened to Jet Airways?
Certainly. Jet Airways was once India's premier private airline, but it ran into severe financial difficulties. In June 2019, the National Company Law Tribunal, LT, admitted State Bank of India's application to initiate corporate insolvency resolution process against Jet Airways. The airline had accumulated admitted claims from financial creditors of approximately 7,800 crores.
That's a substantial amount. What happened next in the resolution process?
After several rounds of bidding, in September 2020, a consortium of Murari Jalan and Florian Fritsch, known as the Successful Resolution Applicant or SRA, submitted a resolution plan. The Committee of Creditor approved this plan with a 99.22% majority vote. The plan included various commitments, including a crucial first tranche payment of 350 crores.
Can you explain what this first tranche payment was meant for?
The 350 crores was meant to be paid within 180 days from what's called the effective date, the date when certain conditions precedent were fulfilled. This money was crucial for various purposes, including CIRP costs, contingency fund, payments to financial creditors, operational creditors, and working capital for business.
I understand there was also something called a performance bank guarantee, or PBG, involved. What was that about?
Yes, the SRA had to provide a performance bank guarantee of 150 crores. This is essentially a security deposit to ensure they would implement the resolution plan. A key dispute in this case was whether this PBG could be adjusted against the first tranche payment of 350 crores.
That's interesting. So what went wrong with the implementation?
Several things. First, there were disputes about whether the conditions precedent had been met, which included getting various approvals like the air operator certificate, slot allotment approvals, and international traffic rights. Then there were issues with the payment of airport dues and employee dues. But the major controversy was about the first tranche payment and whether the PBG could be adjusted against it.
Let's pause here for a moment and explain what these conditions precedent were, as they seem crucial to the case.
The resolution plan listed 5 key conditions precedent that needed to be fulfilled before implementation could begin. These were validation of the Air Operator Certificate, AOC, by aviation authorities, approval of the business plan, slot allotment approval, international traffic rights clearance, and completion of a demerger process.
And there was considerable controversy about whether these conditions were actually met, right?
Exactly. The SRA claimed they achieved all conditions by May 20th, 2022, when they received their AOC. However, the banks disputed this. A particular point of contention was that the AOC later expired on September 3rd, 2023, and wasn't renewed.
This seems like a complex timeline of events. Could you break down the key dates for our listeners?
Of course. The NCLT approved the resolution plan on June 22nd, 2021. Originally, the SRA had 90 days to fulfill the conditions precedent, which could be extended by another 180 days. Through various extensions, the deadline was pushed to May 25th, 2022. The SRA claimed they met all conditions by May 20th, 2022.
And what about the payment obligations? How were they supposed to work?
The SRA was required to make the first tranche payment of 350 crores within 180 days from the effective date. However, despite multiple extensions, the last one being until January 31st, 2024, as per the Supreme Court's order, they failed to make this payment in full. They only paid 200 crores and wanted to adjust the remaining 150 crores against their performance bank guarantee.
That seems to be a crucial point of dispute. What was the legal issue regarding this adjustment?
The key question was whether such an adjustment was permissible under the resolution plan and the IBC framework. The request for resolution plan explicitly stated that the PBG shall not be set off against or used as part of the consideration. However, the SRA argued that certain clauses in the resolution plan allowed for such adjustment.
How did the courts rule on this issue?
The Supreme Court made it very clear in its order dated January 18, 2024, that the PBG couldn't be adjusted against the payment obligation. They directed the SRA to deposit 150 crores in cash by January 31, 2024. When the SRA failed to do this, it became a serious breach of both the court's order and the resolution plan.
There's another interesting aspect here about the employee's dues. Could you explain that situation?
The employee dues situation was quite significant. Initially, the resolution plan provided for payment of 52 crores to workmen and employees. However, the NSLAT, in its order dated October 21, 2022, significantly increased this amount.
What was the reason for this increase?
The NCLAT held that employees and workmen were entitled to full payment of their provident fund and gratuity dues up to the insolvency commencement date. This was crucial because these weren't just contractual obligations, but statutory ones. The total amount came to about 226.6 crores, 14 crores for provident fund dues, 188.2 crores for gratuity, and 24.4 crores as damages for non-payment of provident fund.
That's a substantial increase from the original 52 crores. How did this ruling affect the implementation of the resolution plan?
The Supreme Court upheld this NCLAT order on January 30, 2023, making it clear that these payments were mandatory. The SRA then tried to negotiate a staggered payment schedule for the gratuity amount, but this wasn't acceptable as per the NCLAT's original order, which required full payment to save the plan from violating Section 32E of the IBC.
You mentioned Section 32E of the IBC. Could you explain what that provision is about?
Certainly. Section 32E requires that a resolution plan must not contravene any provisions of law currently in force. In this case, laws regarding provident fund and gratuity payments are mandatory provisions that can't be circumvented through a resolution plan.
There was also a significant issue about airport dues, wasn't there?
Yes, this was another major point of contention. The resolution plan estimated airport dues at 240 crores as of August 2020. However, due to delays in implementation, these dues had ballooned to approximately 1,100 crores by the time of the final judgment.
That's quite an increase. How did the court view this escalation?
The Supreme Court noted that this massive increase in dues was directly attributable to the SRA's delays in implementing the plan. The court rejected the SRA's attempt to limit their liability to 25 crores by arguing that airport dues were part of CRP costs.
This brings us to the court's final decision. What did they ultimately rule?
The Supreme Court delivered a significant ruling that has major implications for insolvency resolution. First, they found that the NCLAT's order allowing adjustment of the 150 crore PBG against the first tranche payment was perverse and unsustainable in law.
And this was a particularly important point because it went against the court's own earlier order from January 18, 2024, right?
Exactly. The court had explicitly directed the SRA to deposit 150 crores in cash by January 31, 2024. When they failed to do this, it was a clear breach of not just the court's order, but also the fundamental terms of the resolution plan.
What about the SRA's argument that their failure to pay was just a breach of the lender's affidavit conditions and not the resolution plan itself?
The court rejected this argument completely. They held that the lender's affidavit couldn't have imposed conditions different from the resolution plan since Section 31(1) of the IBC makes approved resolution plans binding on all stakeholders. The requirement for cash payment was inherent in both the resolution plan and the affidavit.
So what were the consequences the court ordered?
In a landmark decision, the court invoked its powers under Article 142 of the Constitution to directly order the liquidation of Jet Airways. They also ordered the forfeiture of the 200 crores already paid by the SRA, permitted lenders to encash the 150 crore performance bank guarantee, directed NCLT Mumbai to appoint a liquidator immediately.
That's quite remarkable. What was the court's reasoning for taking such a drastic step?
The court emphasized several key factors. 1. 5 years had elapsed since plan approval with no meaningful progress. 2. The SRA had repeatedly failed to meet payment obligations despite multiple extensions. 3. Airport dues had ballooned from 240 crores to 1,100 crores due to delays. 4. Employee dues remained unpaid. 5. Further delays would only erode the remaining value of assets.
Did the court set any important precedents through this judgment?
Yes, this judgment sets several important precedents. First, it establishes that timely implementation is not just a contractual obligation, but a fundamental aspect of the IBC's objectives. The court emphasized that timely liquidation is preferred over an endless resolution process.
And there were some groundbreaking observations about the role of successful resolution applicants, weren't there?
Absolutely. The court emphasized that an SRA's role is not merely transactional. They have a profound responsibility that goes beyond just meeting financial commitments. It's about genuine commitment to reviving the distressed company and ensuring meaningful turnaround.
The court also made some strong observations about the conduct of lenders and creditors, didn't it?
Yes, the court stressed that lenders have an equal obligation to support the implementation process constructively. They can't impede implementation through unnecessary demands or delays. The court called for a collaborative approach where both SRA and lenders work together towards the common goal of revival.
This judgment seems to be a wake-up call for the entire insolvency ecosystem.
Precisely. The court highlighted systemic issues including the need for statutory control over plan implementation, problems with excessive judicial discretion in granting extensions, need for stricter enforcement of timelines, importance of maintaining the integrity of approved resolution plans, role of monitoring committees in supervision.
And the court took the unusual step of sending copies to the Ministry of Finance and IBBI for consideration of reforms, right?
Yes, this shows how seriously the court views these systemic issues. They've essentially provided a roadmap for reforming the IBC framework to make it more effective and efficient.
And that brings us to the end of today's analysis of this landmark judgment. Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast.
Absolutely. And don't forget to tune in tomorrow when we'll be analyzing another fascinating judgment. Until then, this is Priya Matthews.
And Arjun Kapoor, signing off. Thanks for listening to the Ask Junior Daily Judgment Podcast.